Hello everybody and welcome to our webinar on intergenerational trusts and divorce. How do they hold up? This webinar has come about, or this topic has come about, because of a recent case in the family court dealing with a trust that had come down from a previous generation. And it gives us some important guidance on structuring clients who have concerns about the transfer of intergenerational wealth and wanting to make sure that that's effective from a family law claim. So the concepts can apply to trusts that are set up during client's lifetime, or they can apply to trusts that are set up via a testamentary trust via a client's will. Today we've got a new presenter for Cleary, Hoare. He's been with the firm for a few years now, but I'd like to introduce Kev Liyanage, who works out of our Brisbane office. He'll be presenting the webinar today. And I'll be soon turning off my camera and listening in like everybody else. Just a couple of housekeeping things to begin with. We have a copy of the slides available should be appearing on a files button to the right of your screen. And also, if you have any questions during the presentation, if you put them into the chat box, either what's an issue with accessing things, or you've got a question for Kev, just put it in the chat box and we'll be doing questions at the end of the presentation today rather than during it. Presentation should run for about 30 minutes, so there'll be plenty of time for questions during the webinar. If you don't get a chance to ask them, there's also a link at the end of the slides that will take you to Kev's booking page where you can book some time with him to have a chat about them, or you can just shoot them through on the email, those questions. The other thing in terms of the webinar is that it will be recorded and will later be put on our YouTube channel and also linked to our website. So if you do have to step out or you've missed the webinar for some other reason, then you will be able to access that. That usually takes about a week or two before that's uploaded to YouTube. So I'm going to now tune off and introduce Kev, who will present the webinar.
Hi everyone, my name's Kev. So as Adrian said, I'll be presenting this webinar for you guys. And it just considers intergenerational trusts and divorce and how they actually hold up in the long term. So firstly, we often have a lot of clients come to us wanting to protect family assets for their future generations, particularly against divorce and bankruptcy, as that tends to be the big events that assets get carved up. But they also want to maintain control of those assets in the long term with a specified purpose and ensure that those assets, if they ever need to, go to their intended beneficiaries. There is a preservation of family wealth and continuing the business across a long generation, which is pretty much another common client objective. And finally, tax efficiency and maintaining flexibility in distributions is another key objective there. So the agenda for today, we're just going to initially just start about trust and a refresher on trusts and general asset protection, and then go on to how trusts work in family law claims, citing that recent case of Caldwell and Caldwell. And finally, we're just going to end up on Cleary Hoare's bloodline trusts, which is our version of a discretionary trust. So firstly, for a valid trust, you need three aspects, being the trustee, trust property, and beneficiaries. Normally, the trustee can be someone in their personal right or a company. Normally, we recommend a company because the trustee is personally liable when they don't act in good faith or don't act within the terms of the trustee, or they go against the trust. They are confined by their fiduciary duties, which are they must act honestly, act in good faith, and within the trustee. And in exercising all their powers, they have to consider those fiduciary duties, but also they have to consider the best interests of all the beneficiaries, as well as the proper purpose of the trust, which we'll touch on a bit later. One of the background roles in a trust, which tends to get overlooked often, is the appointer or the principal. They only have one role in the trust, and that's to remove the trustee and appoint a replacement. When we deal with succession of trusts, that's the key role that we want to make sure is secured, because they're the ultimate control of the trust. The role and powers of an appointer are a personal right, not a property right. So what that means is they don't actually vest in a trustee in bankruptcy because they can't be divided and they're not actually property. The final aspect of a trust is the beneficiaries. In a normal discretionary trust, the beneficiaries have a very limited set of rights. That is the right to be considered for a distribution and a right for due administration, which is to look at the financials and ensure that the trust is being governed properly. No beneficiary in a discretionary trust is said to have an interest in the trust property. Because it's discretionary, because no beneficiary actually has any right to receive property, their rights are very limited. There are two types of discretionary trusts mainly. The first type is an inter vivos trust. Normally, it's created in someone's life pursuant to a deed of settlement or a declaration of trust. And the second type is what we call a testamentary trust, which is constituted under someone's will and only comes into effect when someone passes away and assets are actually transferred to that trust. So in family law claims, a trust can be considered in two ways. Firstly is property of the marriage, which means that if it's property of the marriage, it can be divided between the parties to the marriage or as a financial resource of one of the parties to the marriage, which means that it can't actually be divided amongst the husband and the wife. Instead, it's just considered when actually dividing up those joint assets. Because at the end of the day, the court will be aiming to make a just and equitable settlement. And if a party has access to a financial resource, they will consider that in dividing up the joint assets. The court does have the power to set aside a transaction in certain circumstances. In trust, it tends to happen when a trust is a sham, which is basically when a trust is created for an improper purpose or specifically created to defeat a spouse's claim. And the court still has the power to alter ownership of a third party, which includes a trust there. So the first case I'm just going to talk about is one of the first trust law / family law cases that people tend to refer to, which is the case of Kennan and Spry. Dr. Spry was a tax barrister, was married in 78 and had 4 daughters. During the marriage, he actually created a trust and was in full control of that trust by being the settlor, the trustee, and having the power to vary the terms of the trust. And during the marriage, he had actually transferred substantial assets from his personal name into the trust. The court had found that Dr. Spry's role as a trustee and his power to appoint trust assets to his wife fell within the definition of property, and that trust was actually deemed as property of the marriage and was divided amongst them. And it is worth mentioning the court did find that Mrs. Spry's right to administration of the trust as a beneficiary was property of the marriage as well. The second case we're going to talk about here is Essex and Essex. Similarly, 2 trusts, but it was created by the husband's mother. And the objective of the trust / the gift was to protect the assets of the mum from the husband's wife. The husband wasn't actually involved in the trust in any administrative role. He was only a beneficiary, but he wasn't a trustee director, nor was he an appointor. So the court had found that because the husband had no control of the trust wasn't actually property of the marriage, and therefore the trusts were protected. The final previous case I want to talk about is the case of Bernard and Bernard. Husband and wife had split up after 27 years of marriage, and they had children. But 3 years before they broke up, the husband's father had died and created 2 testamentary trusts and gifted his whole of his estate to those trusts. The trusts had actually been discretionary in nature, and the husband was a primary beneficiary. And the wife and the children were actually general beneficiaries. Again, similarly to the case of Essex and Essex, the sister was the trustee and the husband wasn't actually involved in the administration of the trust, and the appointor was independent as well. The trust did run a property development partnership, and the income had been accumulated in the trust. And the husband actually hadn't received any distributions and was employed on a salary there. Ultimately, the wife's right to a due administration was hard to value because it was a discretionary trust and because she was a general beneficiary. Her rights to the trust were very, very limited and very hard to value. And the husband and his sister had meticulously documented the trust assets to ensure that none of the assets of the husband were involved in the trust and that the trust assets were kept separate. And the husband had never acted as those assets were his own. He had always acted as the trust assets. So it was determined it wasn't a sham and it was actually protected against these divorce proceedings. So the final case we're going to reference is the case of Caldwell and Caldwell. So this is the recent case that was heard in July of this year, and it was concerned with a husband and wife who had separated in 2022 and divorced in 2023. They had 3 adult children, and they had significant assets together in the relationship. But the husband was involved in a family business. The business was run through 3 discretionary trusts, and they had significant assets in them. And the business, not necessarily the trust, had been established in the early 1900s by the husband's great-grandfather, grandfather, and then his father. And the husband had come into control of those trusts during the separation after his father's death. So the structure of the trust were quite complex, but ultimately 3 trusts controlled the entire family business. Each trust had a corporate trustee, with all the shares being owned by the husband and his 2 adult sons. While they were all joint shareholders, the husband, as the first name shareholder, had the voting power of those shares. So it was then an argument that the husband actually had control of that entire company. And the husband was the appointor, again, shared with his sons, but he did have the power to unilaterally remove his sons as appointors without giving a reason and replace them if he wished. The beneficiaries were extremely limited. In all the trusts, the beneficiaries were only lineal descendants of the husband's family. The wife was expressly excluded from all the trusts, and neither the wife or the husband had ever received a distribution from the trust. Whilst the husband did work in the business, he earned a salary and didn't receive any direct distributions from the trust. So the background of the trust succession on how the husband got into power. The husband's father had done a series of documents in 2021 in various months, appointing the husband and the children as the appointors and ensuring those shares went to those children. And in that year, he had also drafted a codicil, which is on the screen, but the gist of it is that the business was to remain within the family. The trust should be administered in a way that ensures that the business can run to the future, and the benefit of the business and the trust should only be for lineal descendants. The wife's arguments were that because the husband had the appointer role and could remove his sons and was in charge of the company by being the voting shareholder, he effectively had control of the trust, and that control amounted to ownership, because ultimately he could vest the trust or appoint property to himself, and that decision was within the terms of the trust deed. And ultimately, she wanted those trusts to be considered property of the assets, and she wanted 35%, and for that order to come down through Section 79 of the Family Law Act, which is concerned with property. The husband's argument was that the trusts were established by his father and his earlier bloodline. The trusts weren't constituted by him, so the purpose of the trust weren't to hide assets, weren't to protect against a divorce settlement or anything like that. And he applied that even though his sons were appointors with him and he could remove them, and same with the company, the trust purpose was clear. The father's codicil, the limited beneficiaries of the trust, and the fact that the trust had been running for so long meant that the trust had a proper purpose, which was to run the family business for the family members. And he had argued that because the husband and his wife, or because himself and his wife had never received distributions, it wasn't a sham or an alter ego. It stood on its own. And at most, the trust assets were financial resource he had access to, but definitely not property under Section 79. He lastly submitted that as the husband and wife had significant assets outside of the marriage, a just and equitable settlement of that property could be completed without actually using the trust assets. So the trusts were included as respondents in this case, and their arguments were pretty similar to the husband's, again saying that the fiduciary duties of the trustee was to act in the best interests of the trust, as well as exercising the proper purpose, which again was for the husband's lineal descendants to benefit from the family business, for the business to continue on, and for distributions not to occur unless it was for the family. And finally, they argued that the appointor's role or the trustee's role in potentially using those trust assets to satisfy a property claim would be against the role of the trustee and would breach those fiduciary duties. The ultimate decision by the family court was to dismiss the wife's application, highlighting that the trust assets were not property, but instead were a financial resource of the husband. Ultimately, they found that the trust had a proper purpose, being the codicil had outlined what the purpose of the trust was. The trust deed was very, very specific in excluding excluding anyone but bloodline, and that codicil had established that the trusts were to be used for the business, and because they were long-standing, they weren't created by the husband to defeat the claim. So ultimately, they were considered a financial resource, and because the wife was excluded and as the beneficiary, and so was the husband, no distributions could occur to the wife specifically, but distributions could happen to the husband. So it was ultimately found that he would receive less of the joint property. So in getting some lessons from this recent case, it can be seen that a well-drafted trust with a proper purpose holds up in family law matters. Specifically, having a purpose for the trust, limiting beneficiaries, long-standing trust that was created under another family member or parents holds up very, very well. And further, that control doesn't ultimately mean ownership. We saw in Kennan and Spry that the husband had complete control over the trust, and that was deemed to be property. But in this case, even though the husband could ultimately appoint all the property to himself, that amount of control did not amount to ownership because the proper purpose of the trust did limit what the husband could do. It is worth mentioning that even though the trusts are protected in divorce settlements, the assets of the trust will be considered as a financial resource, and the husband or the wife who's party to that trust will actually receive less of the joint assets, which is something that should be considered in the long term. So going on to bloodline trusts, they were developed by Cleary Hoare in the early 1990s. It was in direct response to farmers in the Burdekin who had farming operations and wanted to ensure that the property, the operations, when they went into the next generation, they were protected. If the kids got divorced, they didn't want the farming business to be adversely impacted or the business not to be able to run because of this. So that's why the Bloodline Trust was created. Normally, there are two versions of Bloodline Trust. As I said before, the inter vivos version, which is just made during the life of someone. It's normally made in relation to a deed of settlement. And then there's the testamentary trust version, which is created under someone's will and doesn't actually come into effect or come into play until someone's passed away. So the main aspect of a bloodline trust is that capital can only go to bloodline. So what that means in the aspect of a testamentary trust, the assets of the deceased person, when they go into the trust, those assets can never actually go to anyone other than the bloodline if they ever need to. But the income that's produced from those assets or the income that's produced by whatever means in the trust can actually go to bloodline and other beneficiaries. Normally we'll limit that to spouses, de facto, parents of the primary beneficiaries or brothers and sisters. But ultimately, the capital can only go to the bloodline and income can be shared to those other individuals for flexibility. So just going to go over the structure of bloodline will. So normally under the will, we'll create one trust for each child. If the children are young, we'll normally consider making one trust, but in most cases, one trust for each of the children. They can be appointed as trustees solely, but we normally recommend having someone in there as a co-trustee, normally an accountant or someone trustworthy. That co-trustee doesn't actually have to be involved in the day-to-day running of the trust. They can be involved in those big decisions such as vesting the trust, distributing capital, changing the trustee, and just giving that oversight to ensure that the trust is maintained for that proper purpose. With all of our bloodline trusts, we always execute a letter of wishes. The letter of wishes isn't binding on the trustee, but it gives the trustee the reasoning behind why the testamentary trust was created, situations where capital should go out, and just overall giving that trust outlining what the trust's proper purpose is for. The inter vivos version is pretty similar. It's created pursuant to a deed of settlement, normally for a nominal cash sum, normally $10, $50, and we'll normally recommend having a company as trustee. And the beneficiaries for both the inter vivos trust and the testamentary trust will normally be the deceased individual's children, grandchildren, and great-grandchildren. So in comparing the Caldwell and Caldwell case against the bloodline trusts, it actually supports the bloodline trust in divorce settlements, meaning that because the beneficiaries are so limited and the trust deed cannot be varied to make it so that capital can go to non-bloodline individuals, this aligns with the principles in Caldwell and Caldwell. And in using a bloodline trust for business assets or just general assets in the inter vivos trusts, the assets are never directly owned by the children. Even in the testamentary trust, they never touch the hands of the children. They go straight to the trust. So this protects that long-term wealth and ensures that children can't act as those assets are theirs. Like I said before, the co-independent trustees are a very good idea because it gives that control mechanism and allows for the trustee, if they're going through divorce settlement, if they're going through bankruptcy, to step away from the trust and leave the co-trustee or appoint a family member there whilst those proceedings are going, whilst those proceedings are on foot. And within the trust deed, we can provide succession of trustees, succession of principals, and actually build that into the trust deed or the will to ensure that the future is secure. And finally, the fiduciary duties of the bloodline, of the trustee in the bloodline trust, and the exclusion of non-lineal beneficiary strengthens that strengthens the trust in family law claims. Just some cautions we wanted to flag as well. Land tax is a consideration when putting property into a trust because specifically New South Wales and Queensland have different thresholds for property in a trust. They will be paying land tax at an earlier point, and the main residence exemption won't apply. So the land tax bill will have to be something that is factored in there, and might caution someone instead in putting a property in a trust. The continuing use of the bloodline trusts, the Caldwell and Caldwell case has kind of bolstered it up for us, and ensures that the bloodline trusts are still effective in what we will set them up for, and in ensuring the clients' goals of ensuring that their assets are not carved up in divorce settlements or not put on the table of bankruptcy or in whatever other way that they might be taken away and not used for the bloodline. It ensures that those are protected. And the tax saving of a bloodline will trust in Section 102A1G of flexibility and distributions is also something that should be factored in there. And that's it from me. So if anyone has questions, please put them in the chat, and we can take a look at them.
Thanks, Kev. We'll just give everyone a little bit of time in case there are any questions that they want to fire in. But as I said, you can also contact Kev separately. A little bit more housekeeping. In terms of at the end of the webinar, you'll be receiving a feedback email. It's only got a couple of questions on them on the feedback email, one of which is any further topics that you'd like, and that's how we generate most of our webinar topics. So one for you, Kev, from Mark. Can you give an example of where decisions made by directors of a corporate trustee differ from those of an individual trustee in terms of added protection afforded by the corporate trustee? You're just on mute, Kev.
Sorry about that. The added protection of a corporate trustee is that a corporate trustee is a separate legal entity. It is its own person technically, and when individuals are acting as directors under that, unless they're acting in insolvency or whatever reason, the company will be subject to that liability, and the directors won't be unless they're acting in insolvency or not in their duties as a director. Whilst if the trustees are acting in their personal right, whatever decisions they make, whatever outcomes of those actions, they will be held personally liable. Whilst if it's a corporate trustee, that corporate trustee will be personally liable.
Okay. And so probably more protection from a general asset protection perspective as opposed to family law specific. Another one from Mark, I'll come back to yours, Hannah. With setting up a trust for each child, when would this be done?
So in a testamentary trust, when the kids are normally around over the age of 18, we'll normally recommend having separate trusts for each of them. We recommend one trust when they're a bit younger because they're not going to really have any say in the trust, or they're not going to be involved in the trust. But when they're older, normally they'll want some control of their assets. They want to be talking to their brothers and sisters. So having a separate trust for each of them ensures that it's still divvied up equally, but those kids still have control or still have some sort of feeling of ownership there.
Thanks, Kev. And one from Hannah. What if the trustee is not an individual like the husband, but the company trustee and the husband is the director of the trustee company?
So similarly to the Caldwell and Caldwell case, the husband was the director of the trustee company. It just ultimately comes down to control. The wife's submissions that the husband was in control of the company was fairly accurate because the husband could remove all the directors, appoint himself. That control element was still present, but because the fiduciary duties and the proper purpose of the trust limited his duties, refined his duties as a trustee, that actually helped protect that. but normally the proper purpose and the duties of the trustee will come above wherever and however they're acting.
One from Paul. Paul, I'm just going to modify the question a bit to take out a bit of the personal information since this is recorded. But Kev, the situation is you've got a family trust, which we'll call a mum and dad, dad is not the primary beneficiary or appointer or trustee. Mum is the appointer and primary beneficiary along with son number one. The director, it's a corporate trustee with son number two as director of the corporate trustee. Son number one's getting married and will receive distributions from the trust. Do you think they will be protected in that situation? And your answer can be, it depends. But
so, like Adrian said, it does depend, but because the trust is already set up before the marriage, that already gives it a good amount of protection because it's not made during the marriage to protect those assets. Because the mum's involved in the company and the appointor, that also gives that a lack of control that the son has. If the mum wanted to, she could remove the trustee company, put her own company in there. So that control is very limited. And ultimately, if push came to shove, he could resign as director and leave the trust entirely and just receive no distributions during the marriage or during that divorce settlement. So that would hold up pretty well, but it will depend during the marriage on where those income come into the trust, whether he's using income from their marriage into the trust or property from their marriage into the trust, though.
In terms of next question, Kev, comment, the courts may not get to the trust, but are they generally considered as a financial resource as part of the family law settlement?
Yeah, so normally they will be considered it does depend on the history of the trust and whether it's me making distributions to any of them. But in most circumstances, if the control is there and they are a beneficiary and they have received distributions, it will always be considered some sort of financial resource. But the degree in which that happens will depend on how the trust has been operating.
Yeah. And there's a comment from Paul about the trust being set up 2 years ago before the son number one got involved with his future wife. So again, that adds further to that protective aspect of it. I mean, you could probably look to do further things to the trust deed to increase the protection in terms of excluding particular beneficiaries and those sorts of things. But we'd have to have a look at the deed to have a look at that. For Svetlana, we don't issue CPD hours certificates because each professional body has different requirements there, so we don't issue those. And in terms of the price, give you another lawyer's answer of it depends. Just depends exactly what we're doing in terms of the trust, whether it's part of an estate plan, whether it's part of an inter vivos trust. So obviously the best way to get a bit more clarity on that is to have a meeting with Kev or someone else from the office to talk through the client situation, and we can give an accurate quote from there. Kev, with the Bloodline Wills Trust, can a company be created or appointed as trustee after death?
So in the Bloodline Will Trusts, we don't actually have an appointor because we want to have a clear mode of succession. The trustee does have the power to resign and appoint someone else in their stead, so that can be done after death. But if there is a co-trustee being an accountant, they will have that final say in whether that company comes into that trusteeship. But if for whatever reason we have the child as sole trustee, they can resign and put a company in there. Or if they have an accountant, it can be recommended the accountant become a director, same with that child, and the company be put as trustee after the fact.
What are the downside of having a trustee company as a potential beneficiary?
As a potential beneficiary? Yeah. There's no downsides with that. It's normally kind of preferred. In our bloodline trust deeds, a company is a primary beneficiary if all the shares in that company are owned by the bloodline trust. So there's no downsides, and we still limit the distributions to that company as well. But it can provide that safety net of if someone's income threshold has already hit that 190,000, they want that flexibility, they can give to that, they can distribute to that company. So there's no real downsides of having them as a potential beneficiary. It's just there as a flexibility.
Okay, well, I'm going to close it off there. As I said, keep an eye out for that feedback email. If you could take the time to complete that, it's much appreciated. like to congratulate Kev on his first webinar presentation for Cleary, Hoare. I think you'd agree he did a pretty good job. I won't give him too much praise. But it's not an easy task, of course. Even when you're doing a webinar in terms of public speaking, it's not a lot of fun. And obviously, he's put in a lot of work to get to the position where he can speak so confidently. So with that, we'll close it off. I just see, Hannah, you sent a question through. We'll come back to you separately on that. But thanks everyone for attending.